A nuclear verdict is a verdict where the amount of the damages seems to be so incredibly high, it seems like the case is blown out of proportion. Once you start getting into the $10 million range, I think suddenly it's nuclear.
It's like the lottery. They're looking for the big payoff. They go into these things with, they call it a contingency. It's like, okay, and look at the advertising. We're not going to charge you anything unless we win. Some of them are so bold to say, until we win.
On my side of the equation, the money comes mostly from the insurance companies. That's who hires me to represent the trucking companies. The plaintiffs' bar, on the other hand, they have their own sources of funding. Sometimes they're borrowing money from banks. Sometimes they're borrowing money from litigation lenders.
They've got a lot of money to invest. There are billions of dollars in these lawsuit lending firms looking for what they see as investment opportunities. Some of it is in commercial litigation, some of it is in consumer class actions, but more and more we're seeing this kind of investment in personal injury claims involving defendants who have deep pockets, in other words, trucking companies.
There's two different types. There's the consumer litigation financing, which is the fast cash. The lawyers offer loans, non-recourse loans to plaintiffs for a part of their settlement, charging usurious interest rates that can range all the way up to 60 to 80%. And then we have the commercial litigation financing, where it's the hedge funds, these large million-dollar investors funding litigation portfolios at law firms, driving the practice and pouring millions of dollars into it as an investment opportunity.
But there was one case a while back where a lawsuit lending company offered a plaintiff $200,000, and the condition was that if she recovered in the case, she would owe the lawsuit lender a flat fee of $600,000 plus a percentage of the verdict or of the settlement of whatever she recovered. So $600,000 plus. So say 10% on top of the $600,000. At some point in the litigation, the defendant offered this plaintiff $1 million to settle the case. It was objectively a fair amount. Her own lawyer, the plaintiff's lawyer, wanted to take the deal. He thought it was a good number. It would have made her whole for her injuries. It would have avoided the risks of litigation that she'd recover nothing, depending on how the trial went. She could not take that offer. Because if she took $1 million, her lawyer would have gotten a third of it off the top, right? So now we're down to about, what, $650. The lawsuit lender got its $600,000 flat fee plus its 10% or whatever the number was. Now the plaintiff owes 70 grand or so. So from the plaintiff's perspective, anything less than something like $1.2 million, she was going to be underwater. She was better off going to trial, rolling the dice, potentially getting nothing instead of $1 million. And that's what she had to do because of the way she was boxed in by the lawsuit lending arrangement.
It's a very predatory practice. They're preying on consumers in some of their most vulnerable moments. These loans are offered at a 2 to 4% interest rate per month. However, what's not disclosed is that with compound interest, it can become up to 60 to 80% over annual percentage over the year. And many of these loans can double in as little as 18 months, leaving the plaintiffs in a very vulnerable financial situation.
It doesn't benefit the plaintiffs in a situation like that where they could have walked away with everything they were looking for, and it doesn't benefit the defendant who now has to litigate a trial that otherwise would never have happened. So it completely distorts the process. It means that plaintiffs can't take settlements that they would otherwise be delighted to get.
On the commercial litigation financing side of this industry, the funders are infusing law firms with millions of dollars. And basically it provides these law firms with millions of dollars upfront to go out and advertise, to find plaintiffs to fill their class actions, to bring these lawsuits. They are not taking a close look at whether or not they're frivolous because they don't really care. They're using other people's money and it's allowing them to gamble on these, looking for their next big goose that laid the golden egg. It's really just driving and increasing the amount of litigation that we're seeing, the amount of frivolous litigation, and it's being seen as an investment strategy.
We've had people injured. I mean, we're in a high-risk industry. We've been in business for 30 years. People get hurt. We do all we can to mitigate against that event. And it's very traumatic as an owner to see that anybody's hurt and that we were involved in any way. I would want somebody to be able to be healed to the greatest extent that they're capable and allow them to get back to their regular lives. When you have a $32 million award or these large $500 million award, or you get to the point where you actually put a business out of business, it's not equitable and it's not sustainable. And what's unfortunate is that it's left to business to try to solve this problem because we're not getting any support from the legislative branch, within our government.
We think Congress should require disclosure of litigation lending in highway accident cases. The lawsuit lenders will tell you when they're challenged on this that they're just providing plaintiffs with the ability to either fund their litigation or live while they're waiting for the litigation to play out until they can finally because we all know that litigation can take a long time. Well, if that's the case, they should have no issue with people knowing about this service that they're performing.
It's essential that the judges and specifically the attorneys involved on both sides are aware of these agreements and aware of the third party in the background playing a role in whether or not plaintiffs agree to settlements or what the judgment amount that's being requested is. So all of the parties involved and the judges must know the reasons for this and understand that there are these contracts behind the scenes that are playing a large role.
That's a first step. Second step is to regulate these folks the way genuine lenders are regulated. I mean, every state regulates banks and other kinds of lenders. These lawsuit lenders portray their arrangements as something other than loans. There's no reason they should be treated any differently. They are, in every respect, every meaningful respect from the plaintiff's perspective, a loan and at usurious rates typically. So we think that states should regulate them the same way they regulate other consumer finance products.
Everyone has a vested interest in these abuses being addressed because as a result of as they drive up the increased cost of litigation, there's a trickle-down effect. It drives up the cost of consumer goods, drives up the cost of insurance. Everyone is going to feel the economic impact that this type of lawsuit abuse has.
The trucking companies have gone out of business because they can't pay for the insurance or they can't afford to pay the drivers. I mean, it really has reduced the number of available drivers and caused those costs to transport goods to go up. All of that gets passed on to the consumer. The consumer has to pay that, and ultimately, we're all paying for these problems.